Good evening. Today is the 16th of April 2017 and we're continuing with our update today on the Sajo Oyang Corporation case, giving notice of the upcoming hearing on the 30th of October 2017, and the notices that we have applied for as plaintiffs representing counsel for the Indonesian foreign fishermen who worked on Oyang 70 and Oyang 77, who are seeking a claim against the Sajo Oyang Corporation for unpaid wages, unpaid holiday pay and a sleepover claim, and for personal grievances and extensions in relation to all those claims. We wish to give notice pursuant to 132 of the Employment Relations Act 2000 that if the defendant, the Sajo Oyang Corporation, does not provide its work and timesheet records, that we will be seeking an order that the court accepts as proved all the claims made by the plaintiffs as the defendant's employees in respect of the wages actually paid to the plaintiffs in relation to the hours, days and times worked by the plaintiffs pursuant to section 132 of the Employment Relations Act 2000. The plaintiffs apply for an order that they be paid interest on the arrears of the amount owing for their short pay wages, arrears and for costs. In addition, the plaintiffs claim and apply to the court pursuant to section 219 of the Employment Relations Act 2000 for an order creating and granting an extension of time to permit the plaintiffs to lodge their above applications. This is on the grounds it's in the interests of justice to so order, and upon the further grounds appearing in the memorandum of submissions to be filed by counsel and the affidavits to be filed in support of the application. This application under section 132 of the Employment Relations Act 2000 is also made on the following grounds. If the defendant as the employer failed to keep or fails to produce wage and time records in respect of the plaintiff's employees, and this failure prejudices the plaintiff's ability to bring an accurate claim under section 131 of the Employment Relations Act 2000, the plaintiffs seek to call and produce evidence before this court, being the Employment Court at Christchurch, which we are seeking for transfer to the Auckland Employment Court, for the plaintiffs to produce evidence before this court to show the matters referred to in section 132 round brackets 1, round brackets little a and round brackets little b of the Act. Upon the calling and production of the evidence, if the defendant has failed to keep or fails to produce the wage and time records, unless the defendant proves beyond the balance of all probabilities that the plaintiffs were paid their full wage entitlements under the New Zealand Minimum Wage Act 1983, the 2006 Code of Conduct for Foreign Fishing Crew, the Holidays Act 2003, or otherwise disproves their claims, the plaintiffs seek a determination that the court accepts as proved and valid all the claims made by the plaintiffs in respect of wages and other monies actually paid to the plaintiffs as evidence provided by the plaintiffs of the hours, days and times worked by them on the Oyang vessels, being the Sajo Oyang vessels Oyang 70 and Oyang 77, that they worked here on New Zealand work permits. This application is made in reliance to section 132 of the Employment Relations Act and relies on the following cases. 1. Ideal Services v Dixon, 2011, New Zealand Court of Appeal, 1-4. The Labour Inspector in the Ministry of Business, Innovation and Employment versus Sun to Man Limited, A to Z Cleaners Limited and Love Kumar Kazar, 2016, New Zealand ERA, Wellington, 92. Gull versus Al Jazeera Holdings Limited, trading as ANGSEL Automotive, 2006, NZERA, Wellington, 89, at paragraphs 43, 46, 47 and 48. Sharma and Patel and MOHNAKSI Enterprises, 2015, NZERA, Wellington, 126, at paragraphs 47, 49 and 51, and other relevant cases to be advised by counsel. The extension application under section 219 of the Employment Relations Act 2000 relies on the following cases: Roberts versus the Commissioner of Police, Pruner versus Environmental Decontamination Services, Oraki, Koyarail, Greaseland versus Resort, and the other relevant cases to be notified by counsel. Thank you for your attention.